Over the last year, UK immigration rules have changed faster than ever before. And one route that's exploded in popularity is self-sponsorship and sponsor license-based immigration. But here's the reality nobody talks about. Between July 2024 and June 2025, the Home Office revoked nearly 2,000 sponsor licenses across the UK, more than double the previous year. That means businesses are under more scrutiny than ever before. At the same time, the UK government increased the salary threshold to £41,700 and introduced stricter compliance rules for sponsors. From July 2025, most skilled worker roles also moved to RQF Level 6, graduate level positions only. So the big question is self-sponsorship still possible in 2026? Well, can entrepreneurs still legally move to the UK by setting up or expanding their own businesses? And what are the mistakes causing applications to collapse? Because today, the Home Office is not just checking paperwork anymore. They are conducting compliance audits, reviewing bank payments, analyzing genuine vacancies, and heavily scrutinizing one-person companies. And that's exactly why today's podcast is so important. I'm joined by Amel from Mac25 Immigration, and in this episode, we are breaking down sponsor license rules, self-sponsorship strategy, UK business expansion pathways, ILR and British citizenship roadmap, Home Office compliance checks, and the biggest red flags applicants must avoid in 2026. If you're serious about moving to the UK through businesses, entrepreneurship, or sponsorship, this conversation could genuinely save you time, money, and costly mistakes. So stay till the end because some of the insights in this podcast may completely change how you look at UK immigration. So without any further delay, let me introduce you guys to Amil. Introduction, we are going to start today's topic.
Let's shoot.
Okay, which is all about sponsor license and self-sponsorship. And because we had been talking about this a lot, I'm going to get into little detail in terms of practical problems that people are facing now. Okay. And I have also made a note of some of the numbers which the UK government or Home Office have published on their official channel. So first of all, I'm going to say, somewhere I already read about the number of licenses which had been revoked, I think from last 2 years, from July 2024 to 2025 June. The number of licenses which were revoked were 2,000. Which is a big number. It's a big number. So first of all, I want to know, what is this compliance audit which is happening and why there are so many companies who are losing their licenses now? Let's start with that.
See, in this video, we are only going to talk about the practical aspect of what is exactly happening. I would be giving the client scenarios and stuff like that. And from there on, we'll take it from there.
Yes, definitely. Thank you.
So compliance audit is something where the Home Office is scrutinizing the sponsor with an unannounced audit. Okay. So let's say a company is normally trading and suddenly the Home Office comes to your doorstep and asks, can you please let us know about the number of sponsors, candidate you have? Can you show us the right to work check and stuff like that? Because now the Home Office is mostly not giving the notices. And I have seen this upward trends towards the hospitality and the care sector that just want to come and see what really happening in the business.
Okay. How do they approach them? Do they call them, email them? What is the process?
There are multiple avenues, I would say.
Okay.
So there are two different distinctive Home Offices using. One is the unannounced audit, where the Home Office just turn up in the morning or maybe any time of the day to ask normal questions, routine question about the sponsored workers. Or else, if the Home Office do not have any impatient inquiries, something have not been triggered, so they give at least few days or few weeks of notice that they would be coming to the business and they would be conducting the audit. So that is known as announced audit.
Okay. And what is the common reasons you have seen the Home Office kind of rejects or revokes the licenses now?
See, what I have seen, and I'll tell you only from the practical examples what I've got from my clients, maybe issuing unlimited number of COSs without any rhyme or reason, without a proper justification, just for the sake of hiring individual, God knows for what. But at the end of the day, what we need to understand as sponsors, that things could trigger. Number one would be the COS. Number two, you are not logging into your SMS system on a regular basis, which is the sponsor management system, which obviously the Home Office could track. Number three, you are not being compliant as far as the sponsor duties are concerned as an authorizing officer or maybe as a level 1 user. Something is not working out well. Or the fourth, which is 99% of the reason I have seen, somebody complains about the sponsor.
Oh, what kind of complaint? Is it like a misbehaved, or they are being traumatized at work, or they are being something else? What kind of complaint?
So recently I had a consultation where the client had a warehouse and it was being complained by the neighboring company. That's what he assumes, that somebody from his neighboring company would have complained about him, that maybe the workers are coming at irregular times and they were not sure whether the worker is genuine or not, whether they have got legal tendency in the country and all those sorts of things. And when the home office actually came in, they found out that there was an individual who was working illegally. That means the applicant did not had a right to work in the UK. So most of them are tipped off, most of them are being complained for any sort of reasons. And ironically, I have seen if home office goes for issue A, they found out issue B, C and D as well.
Oh dear.
So this is what is happening.
Okay. Can I ask you a question, maybe not directly related to this topic, but recently there's one reel which on Instagram is going viral. There's someone who's talking about a couple who had been charging, I don't know, 30,000, 40,000 to issue a COS.
Yeah.
And that COS is also fake. So those guys are asking now, there are around 25 people who have already paid this couple this amount.
Yeah.
And that is a fake COS.
Yeah.
Now, as we know, buying a COS and selling a COS, both is illegal in this country.
Yes.
Now these guys are scammed. Around 25 people spend 25 to 30,000 pounds for this fake COS.
Yeah.
What can they do now?
Firstly, there are 2-3 different scenarios, I would say, what we get on a daily basis. At one point of time, that whatever X amount they have paid to the sponsor release the COS, and once they apply for the skilled worker visa, just after the application, they just withdraw the COS. So anyways, the application becomes invalid. Okay, that's point number one. Situation number two, sometimes if you have paid a COS, normally it is a fake COS. It has come maybe through an agency, maybe the sponsor is not right, maybe there is a middleman who's just giving the fake COS out. The only solution you have is be very clean with the home office, and at the end of the day, if you are doing something wrong, then you are in breach of your immigration and you are liable to be deportation or removal from United Kingdom.
Okay.
Yeah.
Thank you, Amil. So going back to the main topic of sponsor license. So everybody thinks, applying for a sponsor license is a straightforward, applying in a single step, it's all done. I know, because we had talked about it a lot, there's a 3-stage application process.
Yeah.
Can you educate my audience or remind them what is that 3-stage process looks like?
Sarika, your audience is much more educated than me as far as
maybe more than me now.
as far as these stages are concerned. But yeah, obviously number one is the sponsor license application, whether we talk about the self sponsorship or whether we talk about a normal sponsor license. Number one stage is that. Number two is a certificate of sponsorship, where you want to hire a migrant worker who's already based in the UK, so you can give them an undefined COS. That's step number two. Step number three, once the COS has been allocated, then you can assign it to the applicant and they can apply for the skilled worker visa.
Okay, thank you, Amil. I'm going to ask the next question just on a plain, simple example. Say I have 2 students now who are not on a student visa now, they are on a graduate visa.
Right.
Okay, and they have set up a company. So is there any formal process to apply in the company house, not for the license, just registering a company? Is there any pre-checks which needs to be done? Or anybody who wants to start a company, they go to a company house, provide the details and set up a company?
As far as the company registration is concerned, that is very straightforward. Maybe you can take the assistance of an accountant, or maybe you can go ahead and register the company yourself if you're on a graduate visa. Obviously, being on a student visa, that do not allow you. But obviously, as a graduate, you can start your own business and you can run your own business and get a license, and you can hire migrants to expand your business as well. So I think registering a company is very straightforward. But when we are talking about sponsor license in general, it's not just about registering a company. There are so many documentation, so many, I would say behind the scenes documentations what you have to make in order to make sure that your company is eligible for a sponsor license, which is being, I think, not being realized by most of the people I have seen, because Now, whenever I do a consultation, they are getting wrong advices, maybe by the friends, maybe by the wrong advisors or agents, that you register the company, you just get X amount of money in the account, just wait for a month and apply for the license. So these are all fear mongering things what I have seen, or maybe lack of awareness. Where if I talk about my company, so MAT25 is very specific. When you talk to a client, we only go ahead with the application if our checkboxes are ticked. If we feel satisfied that yes, you are ready to go ahead for the sponsor license, rather than just rushing because your visa is expiring, or maybe just going ahead and just doing the application for the sake of money. People are not thinking about the credibility. That's where there is a lack of awareness.
Okay. So again, circling back to the same example of two graduate visa holders starting a company, they go to the company house, first step, register their company. Now say they are trading for 6 months and they are able to make some random numbers, say per 2,000 or 3,000 kind of profit per month.
Right.
And now they both want to apply for a license.
Right.
So can you just walk us through, what do they need to do after that?
I'll do something for you.
Yes, please.
For your audience.
Okay.
What I exactly break down in my consultation, the step-by-step structure, I'm going to give it to you for free, entirely free. You don't need to get my consultation. This structure is for Sarika's audience. Okay?
Thank you very much.
So I'm going to break it down. Number one, whenever I start a consultation, the number one thing we check whether the company is registered with the company house, whether you are a limited company, LLC, or you're a sole trader. That's step number one. Step number two, where people get more confused about the kind of a business bank account they need to have. So they need to have a business bank account which is PRA and FCA regulated. That's very important. So most of the banks now in the country, even fintech banks like Monzo and Revolut, is eligible for a sponsor license. Step number three, and the most important part, before having an immigration advisor or a solicitor, you need to get an accountant. You need to make sure your accounting basics are clear. And this is what I tell in all my consultations. You need to register for a PAY. That is the most important part of the sponsor license application. You can go ahead with VAT or choose between the office address, not a virtual one, maybe a co-working would work. After that, you need to make sure pension is the most important aspect what not everyone talks about. You need to be registered with pension because that's not just immigration law, that's the entire employment law of the country. So you need to have a pension regardless of how many people are working. You need to opt them in pension, and they can opt out later on if they want. It's their choice. After that, you need to make sure that your finances are justifiable to the Home Office. You can't be earning 2,000-3,000 pounds a month and expect the Home Office to give you a license with the skilled worker salary, starts from 3,000 itself.
Correct.
Even if you're a new entrant, you need to make sure that this structure is very formalized. And most important thing is the authorizing officer. People always think I can make this person my authorizing officer. This person can communicate well. But you need to understand authorizing officer is the most important part of your sponsor license. He's basically the owner. In my own terms, I would say authorizing officer is the owner of the sponsor license. So you need to get somebody not just by paying them money. They need to make sure your HR system robust. Everything is done in the right way. And that's that about how the structure should work.
Okay. And I think you mentioned previously the authorizing officer needs to be ILR holder or British passport holder.
Yes.
It cannot be anyone just on a different visa category other than this two.
They should be settled and part of the business.
Part of the business as well.
What people miss, Sarika, that they don't put them on salary, or maybe they don't have any shares in the company. Because if you're having an authorizing officer, you need to make sure that they have skin in the game. Otherwise, what's the use of having an authorizing officer? And that's the part of the business. That person should be attached to your company on a permanent basis.
And that person needs to be employed full-time or part-time or few hours in a week? Is there any kind of guidelines around it?
There is no specific guidance about the working hours, but as long as they are part of the business and they are aware about the duties and the responsibilities, then the hours don't matter. And whatever their involvement is in the company, that also doesn't matter if they're attached to the company in a way. But they have to be very responsible about the fact that how the licenses duties are going to work.
So, authorizing officer is the most important person then?
Yes.
As per you. So, whatever audit happens in a company, do you think it is the authorizing officer is the one who gets involved here? Or will it be the two owners or the directors of the company?
you are nowhere involved in this process. It's only the authorizing officer.
Right.
Whether it's a pre-license audit, post-license audit, any issues going on with the ongoing license application for the COS, they would be coming back to the AO, authorizing officer, and the level 1 user and the key contact, which is basically the same person in SMEs. If you look at the company structure, who looks after all the business aspects of it.
Okay.
Yeah.
And you mentioned about they are responsible, the authorizing officer responsible to maintain the whole process, including HR system.
Yeah.
Do you have any guidelines on the HR system? What should the HR system do? So if an authorizing officer is very new to a duty, he may not know what to do, not to do.
Yeah.
So any kind of guidelines, roles and responsibilities, is it written there on the Home Office website?
Of course, there are a few important pillars what I give it to my clients after every consultation, that what needs to be done when the audit comes. People always misconstrue that HR system is always an expensive software they need to buy, which is not true. Many of my clients have got a manual HR system where they make it on notes.
Is that accepted?
Yeah, it is. If you can justify to the home office, the rotas and everything, you have got a written holiday form, that's completely all right. As long as you have got the evidence, home office is never very fussy about the fact that you need to have the specific software or a specific method. The process is important. The efforts are important. There are few of my clients who don't take the software. They use the Excel sheet.
Yeah.
And then there are clients, we are associated with a few HR system companies who help them in the entire setup and stuff like that. So it's all about how you track the visa monitoring, how you do the record keeping, whoever you hire, how you do the record keeping of them, how do you do your reporting duties. Once you hire someone, it becomes your responsibility to track them down and understand whether they're performing well, whether they are having a lot of absences, whether they're turning it up. If you have any issues with the employees, you need to report it within 10 working days in the SMS system. So those are the important 4-5 things what you need to keep in mind. The process should be in any form, but there has to be a process. That is important.
Okay. Thank you, Amel. I'm going to move to the next one, especially around, I want to talk on sole director problem.
Okay.
So we know that Home Office doesn't like this setup. Yeah. Because they are the only stakeholders and only employee, and they want to sponsor themselves. Say. Home Office, of course, they have a real problem with this setup. So why is it an issue, and how serious is the risk, and what is the practical solution around it?
See, many of the clients who wants to do a sponsor license via self-sponsorship, they need to understand one thing. The structure is not a problem, and Home Office is right on this side. I am the director. I am the one who's paying myself salary. I am the one who's signing my own employment contract. So that means I am the one under the control of everything, right? So what the Home Office wants to make sure, and by the way, many of the clients have got the sponsor license with the same structure. But if the Home Office wants to do an audit and they want to see whether you have got a proper HR system, who is responsible for X number of things, then you should be able to justify that to the Home Office. So even if it's a sole director structure, and anyways, you are going to need an authorizing officer in the business who looks after the HR processes. So for me, authorizing officer is like a HR manager. It's as simple as that, who should be looking after all the aspects of this. But as a sole director, you need to understand, if you want to sponsor yourself in the future, have you got a relevant skills? Have you got that specific experience? And is your company doing the same kind of operations or not? Because if you have done IT, you started a restaurant and you want to hire yourself as a sales account manager, it do not matches anywhere. You're getting my point. So the genuineness criteria, what the Home Office has laid out in the guidance, it is really very important.
True. But again, the question is, even though they are the sole director, they will still require an authorizing officer,
Of
right?
course,
Because they need to be the local, either British or ILR holder, isn't it? Okay. Let's talk about SOC code. Now, when I speak to a lot of people and the webinar which I was having today morning, I realized that even now people just don't know what is SOC code. You know? So maybe let's talk about it once again, briefly talking and explaining what is SOC code and why is it so important in the whole process of self-sponsorship.
SOC code, I believe, is like a branch of your entire tree. Okay, so tree, let's say, considered as a sponsor license. SOC code is something, let's say, if you have started an IT business, an IT business is in the domain of software development. Okay, so if a software development company wants to hire a software developer, it has a separate SOC code of 2134. So 2134 is the code for software developers. So you need to identify the specific migrant, whether it's a student, whether you're hiring someone from overseas, and you need to give that specific SOC code to the home office, which is for software developer, which is the entire aspect of that migrant future in the company. So for example, what most people does, there are so many different SOC codes for IT. One SOC code is for IT consultant, one is for software tester, one is for software developer. People just randomly give them the SOC code and they put the description, and at the end of the day, the visa gets refused.
True.
Only on the basis of, see, your company is genuine, the guy is genuine or the girl is genuine, whoever you are hiring. And after that, if you're not putting the right code and the right description which matches it with the right amount of salary, then obviously it leads to refusal.
True. Thank you, Amel. Okay, moving to the next segment, which is about RQF Level 6 rules. As we know, there was a drastic immigration change which was announced last year, and many sectors where they were already struggling to hire the right people in industries like travel industry, hospitality industry, and also maybe care industry as well. And I know your clients as well, because you talked about it in the previous podcast, how your existing clients are struggling who are in that industry.
Of course.
So what have you seen now, how your existing clients are coping up with this change in terms of hiring people at RQF Level 6? And what options do they have now in terms of hiring immigrants, because they are not able to meet the criteria of RQF Level 6? How are they coping up, and what options do they have?
See, their companies have been impacted a lot by this change. Okay, let's be honest. But I want to talk about the solutions rather than talking about the problems. So I have given them a few tips what they can do. Either they can hire somebody who is already on a dependent visa, who do not come under the skilled worker route. That's one thing they can do. Or they can hire somebody who's already on a skilled worker visa with previous rules and working on the same job role and the SOC code. They can hire them as well with, again, the low salary and the same SOC code, because it applies to them, whoever COS was assigned before July 2025. And apart from that, you should look for the local migrants as well. But again, one of my clients said, maybe your South Indian audience would understand. One client just called me and said, who would make dosa for me if I don't get a South Indian chef from India, or maybe who's working here. So I think this is what the kind of direct questions we get from the clients. And obviously, if you want somebody to make a dosa, then you need to find someone in the right set of category, either a dependent or the old skilled worker applicant.
Okay, so they are finding some alternatives to survive
Of
and
course.
make sure their business still kind of work or thrive even in the difficult situation, right? Okay, good. Thank you, Amel, so far. Moving to the next one, which is pretty new for me. I don't know anything about it, so you need to, of course, enlighten us.
Sure.
The new Employment Rights Act 2025. So what is it about, and what changes which is announced recently?
So in the new sponsor guidance, what the Home Office has mentioned, and which is mandatory, it's not a special requirement or something. Home Office has specifically mentioned that now all the sponsors need to circulate an employment right thing to all their employees, whoever is working with them at this point of time, that in writing they need to get it done by the sponsored applicants, that they understand their responsibility as an employee. They need to understand what is happening in the company. They need to understand their employment rights. So what they can do, they can circulate a notice, get it signed with the date, or they can just email and get the acknowledgement back from the employees. So in a way, you are just making sure that you are compliant with the Home Office sponsor duties by making sure that they understand their rights and duties. Let's say, for example, you cannot work, in Uber Eats or Deliveroo or stuff like that, or maybe you cannot work for low skill job roles, or maybe you need to understand that this is your working hours. You cannot be in breach of your immigration law. You need to understand about your absences, and there are plenty of things that the company could add, whatever the roles and responsibility comes within that. But Employment Right Acts, which has been implemented now in 2026, is a mandatory part of it.
Okay, what about people who have already started working long time ago with those sponsor companies? Do they also have to go and update it? For example, if I have already worked with a company, 2 years ago, I got this skilled worker visa from another company.
Right.
So will the HR or the authorizing officer send me a letter?
Of course, yes.
Or they should be doing it?
Yeah, they should be doing it, because if you're currently working with a sponsor, it is their responsibility. Regardless of that, you're working with them for the last 5 years, they need to issue this as soon as possible.
Okay, so when did this Employment Act came into force?
April 2026. Sorry.
March 2026.
Yeah.
Okay,
Yeah.
it's very recent then.
It's very, very recent.
Okay.
Yeah.
Thank you, Amil. So far, I wanted to again touch upon one more topic. What do you have to say? Acquiring a business versus starting from scratch for self-sponsorship visa. What is your take on it? What are the real risks or pitfalls around it?
See, both the things have got their own advantages and disadvantages, right? If you start something from scratch, it will take months for you to build that. That's point number one. If you have got enough time on your graduate route, and if you want to apply for a self-sponsorship, and if you fulfill all the criteria as far as the genuineness is concerned, then you can start your own business. Because acquiring a business is something where you might not like the business, you're just acquiring a business for the sake of getting a sponsor license and getting sponsored on it. But at the end of the day, you need to sustain those things. It's not like whether the business is already trading and have a sponsor license, so you can just jump on that. Firstly, you need to inform the home office within 20 working days there is a change in ownership, and then you need to apply for a new license within 20 working days and get all the documentation in place, and that's how the process would start. So both the things have its own pros and cons, but I always believe, if let's say if you are a registered accountant, qualified accountant, you should start your own accounting firm and do it on the basis of that, rather than just jumping on a business or a food truck or any kind of business just to get self-sponsored.
Okay, thank you, Amil. Yesterday we did our Instagram live, so there were a couple of questions from the audience. Yeah. I remember it, and I'm going to again touch upon it here because maybe my YouTube audience did not watch that. So the question was, somebody applied for this sponsor license and still waiting for a decision for a very long time, whether it was a license or a skilled worker visa, maybe more than 12 months. And you did ask that person to reach out to their local MPs because there was no decision made around it. Right. So in what situations or circumstances you say people to reach out to their local MPs for help?
Yeah. There are many different kinds of situations. So there are delays maybe in terms of sponsor licenses. For sponsor licenses, obviously, I don't suggest to reach local MPs because Home Office takes its own time after the audit, after the interview has been done. Many companies or my clients itself are waiting for more than 6 months now. As far as visas are concerned, obviously, if your visa is in the process, you cannot leave the country.
Correct.
So many people have got some family emergencies back home. One of my client postponed his own wedding because he's waiting for his skilled worker visa for the last 8 months.
8 months?
Yeah, for the last 8 months. And it's not even self-sponsored. It's a normal skilled worker. And so I asked him to reach out his local MP and just see what's happening. And once he reached out to the local MP, he was then invited by the Home Office for the interview.
Right.
So that application is still under process. But until and unless if you feel there is no emergency or something like that and you don't want to leave the country, you should let Home Office take their own time and see. Yeah.
Okay. And do they also explain why are they taking so long? For example, 8 months sounds really big. I mean, on the government portal, they had mentioned generally it takes 3 weeks, 4 weeks for a visa to come through?
8 weeks.
8 weeks, right?
8 weeks.
And 8 weeks versus 8 months is really long, right?
Last year, one of the client applied for an innovator founder visa in Feb 2025. They got the decision just last week.
Oh my God.
Yeah.
It's that long?
Yeah.
Oh dear. Okay. Thank you, Amil. I'm going to ask you another question. Again, this was from Instagram Live yesterday when somebody said, hey, my company's license is revoked.
Yeah.
And now they are left with only, I believe, 60 days to be here in the country or move to another visa categories, or they have to leave the country, right? So how are they protected? Because if a company's license is revoked, it's not their problem. They have not done any issues with it, but the company did not follow the guidelines or the rules, and the impacted people are the sponsored workers, not mainly people who are not sponsored, because it's very easy for them to find a local job. But for people who are on sponsored visas, it's very difficult for them. So first of all, how are they protected? What kind of protection government have given? And is there any kind of transitional arrangements provided to them?
It's a very difficult situation for anyone. Okay. As you rightly said, most of the time it is not the employee's responsibility for the license revocation. So the Home Office sends you a curtailment letter for 60 days when your sponsor license is revoked. But the catch is the curtailment letter takes a bit of time to come. So let's say if the license is revoked today, it will take few months for the Home Office to get back to you for a curtailment letter. And in the curtailment letter, obviously, you're going to get 60 calendar days in order to either switch to any other visa categories or leave the United Kingdom. So you have got that point of time. We don't even know. Some people get the curtailment within 1 week as well. So it depends from the caseworkers, how active they are in terms of that specific company, specific individual. But you have to be very straightforward. You always need to think that 60 days starts from today. Though you will be legal in the country until the day you receive the curtailment letter, but in order to switch to any other visa category or maybe to do something else, you need to start making your own arrangements.
Do you think that will have any impact on the ILR? For example, says I do not get the curtailment letter for 4 months.
Yeah.
And it means I'm not being paid for
Of
4
course,
months. Yeah.
of course.
And when I apply for ILR, I have to give my NI number. And NI number, of course, they can see for say 4 months I did not pay taxes because I was not paid.
Yeah.
So what is the impact on the ILR for these people?
See, they are always protected by something called as 3C leave. So it is not their mistake that they are not getting the curtailment letter.
Okay.
So if let's say if they are applying for any weird visas like SET-P or fee waiver or anything like that, they'll still be protected if they don't get the curtailment letter in time. So that's completely all right. It won't impact their ILR.
Okay. And it's okay for them to stay back in the country till the time they don't receive this curtailment letter from the Home Office,
Of course,
right?
yes.
And they're still considered legal.
Yes, of course.
Okay, good.
Yeah.
That's really good to know. And in terms of transitional arrangements, for example, if they have already got a COS which was issued, say, before 22nd of July 2025, and the company lost the license. Now they're applying to a new company, say on a different job code.
Yeah.
Say initially they were on a data analyst, for example, and now the new job code they want to move is a business analyst from a medium scale to higher scale.
Yeah.
And their previous visa was skilled worker visa. Again, the new visa will be skilled worker visa. In terms of salary threshold, because say it's a part of old rule, they're part of the old rule. Do they need to follow the new going rate or the lower going rate column? Which column do they have to follow?
So there are two things you need to look at it. If their first COS was assigned before 4th of April 2024, then they need to look at the lower going rate.
Okay.
If the COS was assigned like 5th of April 2024, then they have to look at the standard going rate.
Okay, standard.
That is the only date you need to keep in mind.
Okay.
That's it.
Okay. 4th of April 2024, if a COS is issued, you look at the lower going rate.
Exactly.
And if it is issued after 4th of April 2024, you have to look at the new going rate.
Exactly.
That's it?
Yes.
Awesome. Thank you, Amil. Amil, moving to the next part. Now, as we know, through self-sponsorship, people are eligible for ILR because it's a subset of skilled worker visa.
Course,
so how does this journey look like for people who are securing the self-sponsorship visa?
See, this is a very important point I want to tell to your audience about it. Getting a self-sponsorship, skilled worker license, COS and a skilled worker visa, it's not the end. It's the beginning. People forget to understand that once they have received the skilled worker visa, the main duty starts after that. They need to pay their salaries on time. As per the Home Office new rule, which was implemented in 2026, now the Home Office will look at on a monthly salary. Before the rule was that you can pay annually in whichever way you want. Now it is there in the guidance. It is mandatory in the immigration rules. The Home Office has mentioned they are going to track all the employers on a monthly basis, whether they are paying on a monthly basis or not, as far as the annual salaries are concerned. So whatever salary you put down on the COS, it has to be paid on a monthly basis. So people normally forget that. They think, okay, on the COS we have showed 50,000, now we'll pay accordingly. It doesn't work like that. If you actually want to work in your own business, if you want to actually expand your own business and get ILR at the end of the day, whenever you qualify, you need to make sure you're paying yourself the right salary, you are doing your monitoring duties, you are reporting it to the Home Office, and you're fulfilling all the conditions as a proper sponsor who does, whether you are a self-sponsorship candidate or whether you're a British citizen.
Okay.
That is the most important aspect.
Okay. Thank you, Amil. You really touched upon an important point, because I didn't know this
Yeah.
is a recent change,
Yeah,
because
yeah.
previously we talked about it is the annual salary. As long
Of
as you're
course.
getting that is
Yeah,
fine.
yeah.
So it's like a monthly basis, that particular salary needs to be paid, and they need to give
Exactly.
evidence of it
Yeah.
along with it. In the introduction, you talked about SMS. Employers need to update or look at the SMS system.
Yeah.
So how frequently an employer needs to look at the SMS system, and what updates do they need to make in the SMS system?
Two important things. On a monthly basis, even if you're not assigning a COS, even if you're not using your sponsorship management system, just log in, because Home Office regularly sends you a message in there. So regularly, whenever you open the SMS, you'll see the messages in front of you. That's point number one. Point number two, you should keep on changing your password. Many of my clients have been scammed. My own clients who have been a long-standing client of mine, whose SMS password was just being hacked, and they had four COSs. Within a range of 2 hours, all the 4 COSs were gone. And it recently
What
happened.
do you mean by it's gone? What do you mean by that?
Nowadays, it is a common practice I have seen. At least 3 to 4 of my clients' SMS system were hacked. They had the COS, 2 to 4 COS in the SMS system. Somebody changed the password, somebody just assigned the COS to somebody else, and then they're not able to log in. One of my clients is still waiting to hear back because they have complained of business help desk. We don't have the password. We are trying to log in again and again, but that's not happening. So after that, when the things were retrieved, the account was retrieved, they saw all the COSs were gone.
Oh dear.
So the Home Office now says, firstly, it is not allowed for you to give your SMS password to anybody else. Secondly, you need to keep on changing your password again and again.
Okay.
That is very important.
Okay, thank you, Amil. I know again we have covered this previously. Defined COS and undefined COS.
Yeah.
Can you quickly explain?
So defined COS if you want to hire somebody who's from outside of the UK. Undefined COS if you want to hire somebody who's already based in the UK.
Okay, thank you. Okay, Amil, so we are almost wrapping up today's podcast. Any final message or thought for people who are watching this video and who are considering to apply for self-sponsorship?
See, I won't just say about self-sponsorship in specific, but it's for the people and the companies who are looking to apply for a sponsor license in general. Genuineness criteria is the number one criteria what you need to look when you're applying for the license. That's number one thing. Do not aim to apply for a license in rush if your visa is expiring. Anyways, your visa is going to get refused. So it's better if you delay that. You can go back to your home country and then come back again. But at least just don't have that immigration black mark on your company and get a cooling off period of 6 months. Wait, if you're eligible, then go for the application, because different companies have got different scenarios, different industries have got different expectations, whether it's financials, whether it's regulatory requirements and the documentations. Apply when you're ready. That's it.
Okay, thank you, Amil. Sorry, one more question before we go.
Yeah, please.
Some of my audience, they had reached out to me saying because their visa is about to expire, so they are considering applying for FLR and then trying the route for self-sponsorship. What advice do you have? For example, when people can apply for FLR?
See, obviously FLR is a human rights application. Okay, FLR is of two types: family and private life and human rights application. People are misusing FLR.
Correct.
They are just applying for FLR for no rhyme or reason. And it's not just FLR, Sarika. It's about Set P application for refugees. It's fee waiver application, EUSS. We have spoke about it.
Yesterday in
in
Instagram
length.
Live.
Exactly. People are just using it to buy some time. You can make a paid FLR application. It could be a bridging application if there is a genuine reason. You have got a job and your sponsor is waiting for the COS to happen, or maybe your sponsor has already applied for a sponsor license. Apart from those two things, I do not advise anyone. And even if you when you make the FLR application, you actually put down this in your covering letter, the reason you're applying for the FLR application. You can obviously bridge the application because you're not deceiving the Home Office. You're informing them by paying the fees for the FLR application that what is the actual matter. What people do, they apply for the FLR and then they do the self-sponsorship process. It takes months, and obviously they do fee waiver application. It doesn't make any sense. You cannot buy time to start something new.
Correct.
You can only bridge an application when you know that something is already ready, but you need few days or maybe few weeks. And the result of that, people are getting immigration bail where they are getting 1 year of ban.
Correct.
So this is what is happening in reality.
Okay. Ooh. Amil, there's another question which is popping up in my mind now. It's
Yeah.
like one of the clients reached out to me saying the employed applied for a COS
Yeah.
and did not get results. I don't know why. They did
Yeah.
not hear back from Home Office. And the visa was about to end. So in that case, this person, is he legal in this country or should he go back to the home country?
Applying for the COS, Sarika, do not protect your 3C rights.
Okay, does not protect.
So you need to apply for a visa application, only that makes you legal in the country.
Correct.
So applying for the COS or waiting for that do not make any difference. You have to maybe go back and come on a defined, which is an international COS.
Correct. Okay, understood. Thank you, Amil. We did discuss a lot today, and I hope this clarifies a lot of questions that people had been sending me, either booking my meeting, your meeting, or people who are on Instagram.
Yeah.
So I'm going to say for people, if you have questions around sponsor license or the visas are revoked, self-sponsorship, FLR, any kind of legal queries that you have, you can reach out to Amil. All the details about Amil's email ID and how to book his meeting, the details are in my description and also pinned comment. So go and take the legal help that you need today. Thank you, Amil, and all the best to you.
Thank you, Sarika. Thank you, everyone.
Thank you, guys.